Welcome, everyone. Are you all excited? Yay! Yeah, this is going to be so much fun, and we're going to do a lot of interaction, and you're going to learn so much. And I spent the latter part of the week and all day yesterday going over all of the changes, and just to know, get you prepared, there's 68 slides. So in my mind, that's a lot of slides. So we're going to try to run through them and go through the changes pretty quick, but I also want to have time for us to talk about what they mean. So if you don't understand your contracts, then we need to have a meeting. This is what we're doing. We want to make sure that everybody is ahead of what changes are coming. Some contracts are being put into place on June 15th, and some contracts are being put into place on July 1st. And that means that after those dates, those are the contracts that are necessary. So our compliance team knows this, and they're going to tell you if you have an old version of a contract that they're not going to be able to accept it. So it's really frustrating when you go to get your CDA and they're like, oh, that was the wrong buyer's rep agreement. You have to start all back over, go back and get the buyer's rep agreement re-signed because it was the old rep agreement and not the new rep agreement. And that we don't want you to have to go through all of that. So just in general, as a business owner that you all are in this room, you have due diligence to understand what's happening in our industry. And you can find the resources through Trek and through Metrotex and those websites that I constantly look at. You know, if you can't sleep at night and you want to do some scrolling, go to texasrealestate.com and they update a lot of things all the time. Metrotex also has a great resource for us. And then, of course, Trek updates everything as well. We are so excited to have two contract providers in Texas. We can use Trek Forms and we can use TXR, which is the Texas Realtor Forms. And as long as there's one of those, for example, the seller's disclosure is something where some people prefer the Trek form and some people prefer the TXR form. Either way is fine, but you have to use those forms. So if you want to learn more about them, or if you're not sure about the contracts, especially when you're doing a deal and you're uploading your documents to Dotloop. Dotloop is wonderful. It makes our life a lot easier, but they're not always updated in the correct templates. So for you, we have local pro templates in there. And when these contracts change, they don't automatically pull the new templates. So if you see a version that needs to be updated that we may have missed or it's not correct, let us know and we'll go and update them. But to be sure of using the correct version, use the templates that are called Texas Interactive Forms at the bottom. And then those are going to be the most updated forms that you can use. So that's a little tip for you. So are y'all ready to get started? Yay. Earlier, we had a guest and he was talking about your team and how you can rely on others for your team. And he was saying that he helps with, credit score and getting them ready to buy a house. And then his part of his value proposition was, you don't get me for 30 days, you get me for 30 years because we're going to be working together on this transaction, but then many, many more transactions because I'm invested in your real estate life. So building your value proposition is imperative to differentiating yourself from others that are in the industry, but it's also your knowledge with the contracts and what you're guiding them through. If you are very knowledgeable about this, you are going to have the upper hand in the transaction. And I've seen it over and over again, where if we know all of the details, then our negotiations are stronger. So you're ready to get started. Realtors should know. We already know this, that a written buyer agreement is required. The agreement must include 4 elements: a specific disclosure of the amount or rate of compensation. The amount of compensation must be specified clearly and objectively. A term that restricts the broker from receiving compensation for brokerage services from any source that exceeds the amount or rate agreed upon with the buyer in the agreement, which means if the seller is going to pay you in the contract, but your buyer's rep agreement doesn't match the amount that the seller is going to pay you, then the seller cannot pay you more than what's in the buyer's rep agreement. Has anybody had that happen with new construction? Sometimes the new constructions offer bonuses to people. And if your buyer's rep agreement does not match whatever is in the contract for the new construction for what you're earning, you have to go amend that buyer's rep agreement. So that's what that means. A clear statement that broker fees and commissions are not set by law. We know, we get it. It's in everything now. Okay, so buyer's written agreements, they need to be written prior to showing the house. And we've already talked about this. This is old news. This is not new news, but I'm reiterating it because I've seen some contracts that come in where the buyer's rep agreement is later than the contract date. And that's not okay, because if anybody goes back and has a complaint, that's a big no-no. So the buyer's rep agreement has got to be obviously dated prior to where you write the contract. And if they don't show the house, if you don't actually see the house, you still have to write the buyer's rep agreement prior to writing up the contract. Okay, page 1 down, 68 to go. If you want to take a screenshot, this will be posted on all the places. But if you want to, like I said, keep up to date with things, you can go to mymetrotext.com. Those are rules and regulations that our MLS has changed. There's a lot of red lines on that too, but I'm not going to go into all of that today. But there's a few topics that I'll hit. So a new seller's concession, yes or no field has been added to the listing input field. Have you guys seen that when you're putting in your listings? That's meaning seller is offering concessions to the buyer that do not go towards the buyer's broker compensation. So if they say yes there, that doesn't mean that the seller's offering to pay your broker. It's just saying that maybe they're offering to offer some closing costs or something like that for the buyer. Common violations. Photos are a big concern right now. And why not? I mean, I love ChatGPT pictures. Have y'all seen all of those fun little things that you can like put your picture in and then they make you look like a rock star? Or it's really cool. So people have started using that in photography for their photos for their listings. For a number of years, we've done virtual staging, and that's great. It looks, maybe a couch would look good here. But they're talking about like where there's a blank backyard and then you put a oasis pool and patio and everything that's not existing right there. You want to be careful about how much you enhance your photos and do virtual staging. It's a problematic, completely remodeled kitchens. You know, when you go in and you're going to a house and you're like, wow, this is one of those closed off kitchens. And then you have AI remove all the kitchen and put new cabinets and new layout. That's not okay. Major structural upgrades, expensive improvements that do not actually exist. So we get it. Virtually enhanced landscaping. Adding, it says unrealistically green grass. I understand, like, sometimes if the grass is a little brown, you want to kind of lighten it up a little bit, and that's okay because typically it'll turn greener. But if it's like dirt and then you add this, you get the picture. QR codes are not permitted in listing photos or attached documents, and QR codes contact information is only permitted in private remark, agent remarks, and showing instructions. And then text overlays. We can't add any like promotional text. I've seen a couple people recently where they would put like their name as a watermark or whatever. We can't do that either. Not really even supposed to be photos showing your son. Correct. That will be flagged. Yeah. So you'll get an email from the MLS that says, you need to fix this. So we need to fix it. They'll give you a warning and then they'll issue a fine. So short sale, have y'all seen short sales starting to become more of a thing now? You can't list short sale information in the public property description. So you can't say this is a short sale because that gives away too much information about the owners. So you can list it in the private remarks, but it says short sale disclosures may only appear in the designated short sale field or private agent remarks. And if you don't know about short sales, I know we had a class on this a couple months ago, but learn about them. Jamie is one of our experts and she can help you. And if you have a short sale that you need assistance with, partner with her. and anybody else who wants to like focus on short sales, it's not really a sell that is short. It takes a long time, but it really can help some people. But there's some new rules about that too. A active option contract. If the option period is extended, the expiration date must also be updated in the MLS. We know that. If they want 5 extra days, don't forget to go back to the MLS and add the 5 extra days. And this is one thing that I wish Texas would fix just because of all of the discussion around it. As soon as we move the contract to active option, then we know as realtors, sometimes it might move back to active. And it's still active where you can receive other offers, but the majority of people don't go look at those houses because they're already under contract. Well, a lot of them have fallen out, but not enough to make it where you want to take an hour and go show a house that's already under contract. Texas makes us move it through the process. So when you go under contract and you have to change it to active option, just know that like you want to make sure you verified their funds. You want to do a lot of due diligence up front to make sure that that contract is good for your client so that you can move it and then go down the process and hopefully everything works out. There's people that don't do that. And it's been under contract for a week. It's in off and it still says active. And it's like, you did not change it. Or when it goes to pending, they haven't changed it to pending yet because they're just waiting it out. So we can't wait it out, but that's the problem with it. Yes.
On status while we're on that. So I had one that was sitting in coming soon for about 3 weeks, and then it was going active that day. So I popped up early that morning and was going to change it to active, and it wouldn't let me change it. Tried to call them. They said, "Well, just sometime today we'll change it." And I said, "Well, that's just not acceptable to me. It's supposed to go active today.
Yeah.
It won't let me do that. I don't usually put them in there coming soon. I mean, do they have to do it by a certain time, or can they just do it whenever they want to do it?"
Who?
I thought it was only 3 days. You could only be coming soon.
Oh.
No, coming soon is 30 days.
30 days.
Yeah, it's 30 days.
And so on that day, it knew it's supposed to go live. It'll just go live sometime today. And I'm like, that's not. And I told them 3 times that they end up by that next minute. I was like, it's 3 o'clock.
The MLS
Yeah.
cooperation, broker cooperation agreement is also changed. It's okay to show a listing agent can show a coming soon listing now.
Yeah.
As well.
So MetroTex was 30 days and CCAR was 15 days. So now that we're at MetroTex, it's 30 days too that you can have coming soon.
But like I said, the caveat is I just had.
You don't know when
it wouldn't let me.
You couldn't just click the button to make it active.
It says because it was in there coming soon, that they would just change it themselves sometime that day.
Well, I would call the MLS and have them do it right then. Uh,
Standard on the time they're supposed to do it, or
I don't know.
Control over it.
Okay. Now we'll move on to the contract changes. And here's just a overview of what the biggest things are. The revisions to paragraph 12. Again, paragraph 12 is changing. And so we were memorizing these fun little 12A1B means broker and 12A1C means concession. Well, that doesn't work anymore. It's not hard, but I'll show you. New disclosure requirements involving insurance history, conservation easements, private roads, storage tanks, and water rights. The biggest thing that keeps coming to my mind is the groundwater thing that we're going to learn about, that there's more disclosures that are required now based on what they put on the disclosure. Updates to notice delivery methods. So it says including overnight courier, because I guess there was a problem with that. So now they need to include that a delivery method of overnight courier works. Reorganize addenda and notices section for improved clarity and consistency. Removal of broker-to-broker compensation language from a lot of the forms. New forms related to water disclosures, property conditions, and listing agreement amendments. The broker-to-broker is no longer. We were doing both because we were like, okay, we're allowed to do both, so we can do both. But now we're not allowed to do both. So what that means for you is when you go to a listing appointment, you get to say, I charge this. And then expect for another agent to put it in the contract as far as what they're requesting for their compensation. And it's going to happen. So we'll negotiate it when we get there. But some of the listing agents, you guys can chime in when we get to that part and we can talk about how we have that conversation. But the groundwater and surface water rights, this is the form that just keeps being brought up over all of these improvements. So apparently there's a big deal about groundwater and surface water and the disclosures of that. So they created a brand new form that talks about the disclosures of groundwater. If you don't know if the property that you're listing is in a groundwater district, you go to that website, tagd.halff.com, or you Google groundwater districts in Texas. It'll lead you to a map and you can see. And just for your knowledge, most of Denton, most of Collin, most of Tarrant are in groundwater. Some of Dallas is not. So you'll look at that map. And then if it's in that area, you have to include an additional seller's disclosure notice about groundwater. And this is what it looks like. It's 2 pages. And it's the same thing as your seller's disclosure notice where you don't touch it. This is something that your seller fills out, not the agent. So in addition to the disclosure you choose, if they say they have groundwater or you notice it because you did your due diligence and you looked it up before you went to the property with the paperwork, you add this to that form. Yes.
Seller Shield will integrate this?
They should, based on the answer to that question in the seller's disclosure. We can call them. You want to talk about Seller Shield?
That I like them. And in there because I just as a notice to just remind everybody to use that Seller Shield service because it does help and it keeps us out of trouble. And it will help keep us out of trouble and it's very good service. Everybody that we have as a listing is allowed to have a seller's disclosure. We use them and it is very, very helpful. You don't have to pay for the prepaid legal that they advertise on there. I think that's where they make some money. And I think there is a second option of additional insurance coverage and that you may want to have them use, but.
I'm just showing the people online that you're
Oh,
talking.
okay. So yeah, they have some options of different things that they do, but they do walk them through that seller's disclosure. And the main thing to keep you out of trouble is you do not help them fill out the seller's disclosure ever, because that exposes you to risk. And if there is some sort of litigation or anything that happens and you did help them with that, you're drawn into it and you're just as liable as they are. So don't do that. Use them. Yes, please interject.
Yeah, so we have them fill it out because I love Seller Shield too. But what if they don't know about the groundwater thing? But I did my due diligence and I know they are. Do I tell them, mark yes?
You give them the documentation.
You give them a document, yeah, I'd send them that map. Say, hey, now
Okay.
you know.
Okay.
Yeah, that's a good point. Send them the link to the map.
I look online at the 10,000 better map. It's fine.
Yeah.
Like, I'm not gonna tell you it's there, but you can go look at it. Here's the website.
Exactly.
Maybe
And
install.
verbally.
I
was verbally without seeing treatment.
Okay.
She does it in an hour, CE class, we ought to have her, because Amy Henshaw has done all the water stuff.
Okay.
She knows what's happening with all that.
All right. Let's do it. Who wants to have a groundwater class? I know you do learn the most in
Groundwater thing is probably gonna be required, for any time you have acreage property, large properties, things like that. And most of the cities aren't gonna be, trust the seller's disclosure. And I can almost, I love Seller Shield as well. Hopefully every single listing agent is using Seller Shield. It's in the hub under your systems, easily accessible and available. It gives you the option of using TREG or Texas Realtor forms. If you input that the property is built prior to 1978, automatically adds the lead-based paint. And I can almost guarantee you this addendum is probably already in there. If they check yes to any of the questions in the seller's disclosure, this will be automatically added.
Okay, so some new trick forms, the addendum for backup contract, the changes, the amended effective date to the date the seller delivers the notice of termination. So what that means is when we used to put in a backup offer, then the date that goes into the box there used to be when the buyer receives the notice, but now it's when the seller sends the notice. And then it capitalizes on legal holiday and effective date and changes option fee to lowercase. They did a lot of lowercase and uppercase because they only want uppercase to be words that they have definitions for. Yes.
I'm actually stepping back one just because I don't know who does and who doesn't do Wise County. But Wise County on the water thing, we have our own water thing. And it's not part of we have to, as a realtor who's out there and works out there, you have to know it, so you have to pull it down. It's a funny little form, but you have to notice, you have to let them know there's a little tax.
Yeah.
On watershed,
So
the part of watershed.
it's even bigger than that, it's really.
Yeah.
So if you do anything in Wise County, you're not sure what you're doing, call me.
Perfect.
This development,
So
so I'll
awesome.
about it. So I don't know if others are here that do Wise County, but
Perfect.
keep yourself safe.
Perfect. So all of these like blue and red things here are just changing the capitalization. But here is for purposes of performance, the effective date of the backup contract is the date the seller delivers the notice instead of the buyer receives it. So that's just a little change there. And then addendum for property subject to mandatory membership in an owners association, which I wish they would just put HOA because this is the hardest one for me to search whenever I'm trying to find it. I'm like, what is it called again? But paragraph A2 was updated so that if the buyer obtains the subdivision information, they are not obligated to provide it to the seller. It used to be like the seller would get it, the buyer would get it, and then they'd have to share it with each other. Well, now if the buyer gets it, then they don't have to share it back with the seller because the buyer needed the information to make the decision, and now they don't have to share it back. And it adds a statement to paragraph C that if there is any conflict with the allocation of charges in the subdivision information paragraph, C will control. And then some capitalizations. So,
Really huge. I mean,
yeah.
there's a lot of HOAs that have rules that mandate who pays what fees. And so the challenge has been that paragraph C always read the buyer's gonna pay up to a certain amount of money. But if the HOA says, well, 600, the buyer's required to pay $600 initiation fee. But we negotiated 175 here. What is, the buyers have argued that I'm supposed, why am I gonna pay the $600? Well, and so it's arguable, well, the HOA said the buyer's supposed to pay. But
Why would the HOA commissioner refuse it? Can you just put it on the seller?
that's a great question. I don't really know why. Just some HOAs say the buyer, well, like for instance, when you move out of a master plan community like Castle Hills, the seller's required to pay an additional 1% fee when they move out of that community.
Tribute has 0.5% transfer fee, but I always put it on the seller.
Yeah.
Whoever, it's not my fault.
Well,
Mhm.
and so whoever's the better negotiator, so the argument for the buyer is, or for the seller, is I don't have to pay that $600 because the HOA says the buyer pays it. And so, but this now this clarifies that despite what the HOA says,
Yeah,
if we agree that we're only paying up to $175, then the buyer's only paying $175, the seller's obligated to pay the rest.
Yeah. Yeah.
Make sense? And this is why, and I'm so glad you mentioned that, because this is why, if you've been in contracts class, maybe I'm telling you, if your property is in an HOA, you need to be ordering these HOA docs when you list the property.
Please.
And how cool would it be to be able to select option 4 on this addendum, which states that the buyer has received the HOA docs and thereby there's no further contingencies regarding the HOA. So you eliminate that unrestricted right to be able to terminate because they want to object to something. Does that make sense?
Yeah.
Really think about it. And you'll know what the fees are. The resale certificate will tell you what the transfer fee is. If the buyer's required to pay a certain fee, so that way I know when an offer comes in, I need to make sure it says $600 in here, not 175. Otherwise, my client, the seller, is going to be mad at who? Yeah. For not looking out for them. Make sense? It's just due diligent. I'm still trying to be perfect. The way docs and in advance.
Yay. Okay, the trek forms, now those are trek forms that are updated, not new forms, but these are updated forms. These revised and new trek forms may be used on a voluntary basis, but they are effective mandatory on July 1st. The amendment to a contract, updated to align with the revised broker compensation provisions in paragraph 12 of the contracts. The seller has the option to contribute to buyer's broker compensation. And the buyer now has the option to contribute to the seller's broker compensation.
Agent compensation. How about that?
I'm so glad that you're the only one excited about that.
Not excited?
We're like, wait, what? Oh, now my buyer can pay for your listing agent too? So they're saying if the buyer can pay for it, the seller can pay for it. Here's the amendment. If you have an amendment, it says right here, the seller will pay or the buyer will pay. Typical amendment stuff, they change the capitalizations. Here's the seller's disclosure updates. Now that I told you a minute ago, there's two versions. There's a Trek version and Texas Realtors version. What version do you like better? Because Seller's Shield uses both. Which one's the longer version? Texas Realtors? Yeah. I like the Texas Realtors ones because there's check boxes and I just like how it looks. But there's also a little bit more information that I feel like that's you can find. But you can use either one. But when you're doing your Seller Shield, they'll ask you which one you want to use. And I prefer that version. Addendum for seller's disclosure of information on lead-based paint. They basically just changed the name to buyer's broker and seller's broker. So instead of saying listing agent, we're going to say seller's broker or seller's agent now instead of listing agent. But buyer's broker and seller's broker are what they are changing that to. Now they updated a bunch of sections in all of the contracts, like 1 to 4, new home, farm and ranch, and that's what these are. They added the word generators to the list of property improvements to reflect the increased prevalence of generators. Legal holidays is now defined term in 5A2 to provide better clarity. Legal holidays means a legal holiday described in sections of the Texas Government Code. New Year's Day, President's Day, Memorial Day, Emancipation Day, Independence Day, Veterans Day, Thanksgiving Day, and the Friday after Thanksgiving Day, Christmas Day. 1 to 4 contract. It just changed the capitalization of the word option fee, but right here in the improvements, that's where they added the word generators. And if you don't know what it says in that improvements section right there, memorize that because that is what is going to convey. Accessories as well. Memorize those 2 paragraphs so you know, like when we're talking about what's going with the property or not going with the property. It says kitchen equipment. The one that does not go right now is washer and dryer and refrigerator. I know I've had to buy a refrigerator. Anybody else? Because I forgot to exclude it and then they took it and then I bought them a new refrigerator. Updates to Trek forms, general changes. We just showed that. This is the other thing. The Sunset Commission, this is where all of this groundwater and everything and all of these disclosures are coming from. So we already talked about that. This just goes into more detail of the red lines and the things changed to the seller's disclosure here, where it says that the buyer has received a seller's disclosure notice. They added capitalization to seller's disclosure and they verified that it's the seller's disclosure because on the next page, it's the seller's disclosure about groundwater and surface rights. So there's a whole new section in our contract about this. Another page. Yay. And then if the buyer has received it, has not received it, same type of idea, but it gives them more details about that. Now the paragraph 12s. These are the ones that talk about the fees. So 12A is now titled expenses, and that does not include brokerage fees. Now 12B does include broker's fees. Show you. So here's 12 down here, and it says expenses. All the fees that must be paid prior to closing for an amount not to exceed whatever. That is 12A. That is seller's expenses. And then let me go to the other page.
So that'll be like the concessions will be in 12A.
Yes. Yep. A is concessions now, correct. And yes. And they labeled it expenses to be applied to buyer's expenses other than broker compensation. And then B on the next section is brokerage compensation. And that's where they added seller will pay towards the compensation on the buyer side, or buyer will pay compensation to the seller side. So they added that as in addition on the amendment and on the contract. Yeah.
We had a really hard time with us using paragraph 12, thinking that that was the buyer's side.
So this is where we say, put your compensation in the contract. No longer can we rely on broker to broker. And we've had some people lose out on compensation because they didn't do a broker to broker before they submitted a contract. And then they went back after the contract was executed and asked for their compensation from the other broker. And the other broker said, we don't do that. We don't do broker to broker compensation. So they lost out on $14,000 because they didn't do this up front, or it was not included in the contract. So let's learn.
So,
Nope. Nope. It's in the contract. Yep. Now, the amount that's in the contract, once they agree to, needs to match what? Yes. Buyer's rep. Good job, Jenny.
No, she's.
I wonder if putting an amount of money versus percent would be better.
Amount or a percent? It's up to you.
If they see an amount of money, they might not. I know I did it once and it seemed like it caused less issue than with the percent. Oh, really? Oh, that's.
Yep.
But it was the same amount. I mean, if you're.
So they added governmental requirements, remove the word federal, and this is where we talk about foreign persons. So the other section on 21, this is where the guest that we had earlier was talking to us about where the notices are going to be delivered. This is where they've added to buyers, to sellers, or to the buyer's agent and the seller's agent. Because typically we would just put our address there. Don't be afraid to give their email away. And you don't want the liability to not forward on any important messages from the title company in order to make this an issue, right? So put their information there.
Blank on a legal contract that requires that.
Yeah.
We didn't add it just to say, I'm gonna give up your email address.
Yeah.
You explain to them that it's a way for other parties besides myself to be able to reach you. It could be very important.
Yep. So that's there.
There was actually 2 lawsuits in the last year, regarding paragraph 21, where, regarding performance. And so because the buyer's information was in there, but so was the agent's information, they only delivered it to the agent and not to. Paragraph 21 is about performing every paragraph of the contract. Where do we send the seller's disclosure notice? Where am I selling the HOA docs? And if I think agents are going to look at this and think, oh, I can choose between seller or me. No, you cannot. I mean, you need to put your client's information in here. And its performance needs to go to your client. If HOA docs come to you and you only put a 1-day review period in there and you're busy showing and those docs aren't delivered to your client and they want to object to something and you don't perform, and you don't present it to the client, and the liability is all on you. This is all about the client. And so, but if the other agents or make contact with your people, that's a violation of the code of ethics. And so they cannot make contact with somebody who they know is actively represented by another broker. Okay, so you guys can feel confident with this, but this is really important.
Yep. And the address needs to be where they live, like where they will receive mail if you're doing an address. You can do an email address, totally fine. But if you do the address, don't put an address of the property if that's not where they can actually receive their stuff. I know it sounds elementary, but and then 22, they organized all of the additional things that are addendums that go with the contract. So instead of having just a bunch to choose from that was in the bottom of the page, yep. Now they've got financial addendums, leasing addendums, additional tests and reports, statutory disclosures and notices, and then it says notice seller's failure to provide applicable statutory disclosures and notices may provide the buyer with remedies or rights to terminate this contract. And then it says other. So the non-realty items, it's got the mandatory membership in homeowners association. So they just organized so that you won't forget to check one of those boxes if you have something going on there.
Oh, and just a little for your information. If you forget to do the non-realty items during the regular contract, make sure you do an amendment with it. Because the amendment is what connects it to the contract.
Right. Yay. Okay, 1 to 4 family residential contract. Additional pages. Look, they've added a easier way for us to input our broker contact information. So it says blank represents the seller as seller's agent, blank represents the buyer as buyer's agent, and then blank represents the seller and buyer as intermediary. And if that's the case, that means Jenny represents one party and Emily represents another party, and they're both at local pro, so they're under the intermediary. So Jenny's name goes under the seller and Emily's name goes under the buyer. So nobody. Oh yeah, local pro realty. Yes, sorry. I thought you meant up here. Yep. So if you're not selling something with a local pro agent, then it goes in the top box. And if you are, it goes in the second box, and then both of your names go in the bottom box. That. We do? Yeah. Yep. Yes, we do. We need that. We need all the forms. Yeah, because then that this is just disclosure of who's a party to it. It doesn't like give the information about what intermediary means to the client. Okay. Removal of contingency under addendum for backup. The seller should indicate that the date of the notice of termination, we already said that. That was when the seller delivers the notice, not the buyer. And here's just the example of the new form.
Can you go back?
Mhm.
We do a pop quiz on this page real quick. So what does amended effective date mean? Yeah, what? Amended effective date?
They could be changed.
It would be like when, if your backup contract goes into effect, it'd be the day that it starts.
Changes that effective date. That's what this notice does. So we execute. And then we get notified, we become primary, so we execute on January 1st. And then we receive this notice on January 10th. The new effective date becomes
January 10th.
January 10th.
You know what? I have an elementary question about.
There's
this.
no thing.
It's a bit-
Ask whatever you
something I have
want.
a really hard time. So say you are a backup contract and the original offer was for a 30-day closing. What closing date do you put? Because there's not an amended closing date. What closing date? It would be.
Great question.
But you take 30 days? No, because you pick a day as your closing date. So if this goes 15 days, well now, and it executes, now I only have a 15-day closing. So what do you guys do? Would you amend the closing? I do it after I know their amount of option period, but I really don't know the answer.
I would do an amendment, no?
Yeah, once you're under contract, then that same day. Then we an amendment for
You
them.
can write it on the contract as a revision that if your offer has been accepted, the terms and conditions will start that day that it's been accepted.
What would your answer say?
Then after if the contract's executed, then to me, anything that happens to that contract that you want to attach to that contract is an amendment.
So we just amend and change the closing date. Is that the broker answer?
No, yes, it's to do an amendment.
I think the best answer is,
I'd try to hurry up and get it closed by that date.
I think the best answer is how long, that date could be, how long the buyer's willing to wait to find out if we're primary or not. So if it's a 30-day close, I mean, obviously I'm gonna keep, if this ain't gonna be in the right house, I'm gonna keep showing my buyer houses. You know, are we wanting to wait 2 weeks, 3 weeks? You could put all the way up to the day of closing of the primary contract. And I mean, we're gonna keep looking at housing, and of course, for the purposes of performance, I can terminate because the option period begins on the effective day and continues through the amended effective day for the option period. So if it's January 1st and we execute, but we do a 10-day period, I mean, a 5-day option period, but we get notified on the 10th, well, that option period continues to be in effect, and I can terminate for the buyer if I find another house, and I just have to give up that earnest money.
You can terminate the backup contract at any time prior to it being effective. And if you are putting in a backup contract, you still have to deliver earnest money and option money. So instead of doing what you would really do for earnest money and option money, do small amounts like $100 for the earnest money and $10 for the option money. So that way, if it never gets to first position, you're only out $10.
Beautiful.
I have an attorney with independence write up words that my people don't have to give any money. Is that
Perfect.
okay?
Yes. An attorney can write up words to whatever your client's wishes are. Yep. Okay.
I thought you could have without consideration. How do you get around that?
I don't know. But I just had them write it up.
Earnest money or option money is not neither required to have to ratify a contract in Texas. You don't even have to have earnest money.
Maybe.
It'd be stupid to execute a contract without earnest money, but
And it just, it
you
says
don't
that
have to have.
after its effective date, then you have to turn in that full amount.
But if I don't pay option money,
For the
it
back.
does clearly state in the contract, if there is no option money, then there is no option.
There is
period.
option
But
period.
it's in the words of the attorney. really.
She means the attorney said you don't have to pay anything until the effective amended date.
But you're-
And then you pay, and then the time period starts.
Would she be cognizant of
It's not like that. I mean,
So we did a backup contract the other day and we did $100 and then if we become effective, then I'll give you.
The rest.
yeah.
So-
Yeah. So the next page of the exclusive right to sell, they just took out all the broker compensation stuff and they replaced it with here, the broker's fee when earned and payable is a percentage or an additional amount or a blank. And so some people are like, what if I want to do a flat fee because they just want me to write a contract? So that could go in the third blank. And then the option has been, if broker acts as an intermediary, seller understands that seller remains responsible for payment of the brokerage fee specified in paragraph 5A above and any amount the seller agrees to pay towards the buyer's brokerage compensation. If you have a situation where your seller says, hey, Bob might buy this house, so I'm going to wait and find out if Bob buys it before I list it with you. You can use one of these to exclude Bob from owing you any compensation to go ahead and list it if that's what your seller and you agree to. That way it says like if Bob buys it, then I'm not facilitating, I'm no longer representing you. That's fine. But I'm going to try to find other buyers for you in case Bob doesn't buy it. The words say that if broker acts as an intermediary, seller understands that seller remains responsible for payments of the broker's fee specified in paragraph 5A above and any amount seller agrees to pay towards the buyer's brokerage compensation under paragraph 12B1 of the contract. Quickly, again, back to the seller's disclosure, because we're doing truck forms and Texas Realtor forms, they do similar things, but they are adding a huge section on insurance. Has your house had insurance? Is it currently insured? Have you ever submitted any insurance claims? It asks you all of those things now in the seller's disclosure. We can find that in a clue report anyway, but now it puts it on the seller's disclosure in more detail. And there's a space to disclose the property security system and provider and phone number for the security system. We no longer, and our agents don't do this, but don't leave market area blank. You know, on the contract, on the buyer's rep agreement, if you say none or leave it blank, then that means you don't represent them in any area or no area. So put it by the city, the county. You have to be a little bit more specific than everywhere, but put Denton County, Collin County, or all the counties that you plan on working them with. Or if they want you to represent them just for that one house, then you can put that there for that one house, and then that would cover them and you for the one property that you show them. Okay, so it gives us a paragraph about that the clients that are working with other realtors are able to go to other open houses, but it says attendance at open houses or property showings with other brokers or sales agents where no advice, opinions, negotiations, or substantive broker services are provided does not violate these obligations. Because I guess they were saying, like, you can't go to open houses because I'm representing you. Well, that's silly. So they can do that. And then the source of compensation has changed. No intermediary status. It just gives you a little bit examples of how they added more verbiage there. This does not to be confused with a brokerage to broker fee, but a notification has been added to the general information form that we have to give everybody that says a broker may pay or receive a referral fee to or from another broker. Because I'm sure that question got brought up when they said there's no more broker to broker. They're probably said, well, what about referral fees? They're like, oh yeah, we could still do that. So that's why it's been added. Condo contract, similar to the changes in the 1-to-4 contracts, but the condo includes both disclosures and that. So it's just the same changes, but all in one contract that we've already discussed. So if you want to read about condo contract changes, it's similar to the 1-to-4. Clarification was added that sight unseen refers to a property not physically viewed in person. There is a form called the Buyer's Walkthrough Confirmation and Acceptance Form, which I think you should use.
I use it on every one of my buyer deals. It's one of my
Yeah.
favorite forms.
And it's gotten more detailed. I like it now. Otherwise, it was just a piece of paper.
I would love for you to use this form because then down the road, you can say, you saw that and you accepted it, and I have your signature on this, and that's a CYA that really helps you.
Confirm walkthrough, we confirm inspection, we confirm home warranty.
Re-inspect those.
There's 5 items on there. I forgot what the other
Yeah.
2 are, but it's a great form.
Great.
Hey, it's part of my buyer packet that I send to all my buyers. You can customize your own. No, you know, guys, our compliance checklist is about your E&O requirements and your brokerage requirements to minimally cover you and your client with E&O coverage. But there's so many forms in the Texas Realtor Library and TREC and Netris. I mean, like for your protection, get a home inspection. I mean, I know that's required for FHA, but I just included in every one of my buyer packets. Plus it reminds me to have a conversation. I love the notices to buyer and seller regarding homeowners insurance. That's one of my favorite forms. Again, it reminds me to have a conversation with my client about the importance of homeowners ownership. If we do a lease back, homeowners insurance can be affected, coverage can be affected. You know, if we close, homeowners insurance ends, and if there's a lease back and something happens to the house, something could happen, you know, these are just ways of reminding yourself of having these important conversations about our journey together to help you have a successful closing. Things that we need to talk about, walkthroughs, sight unseen, home warranties, things like that.
Yep. And then they added a critical dates list a few months ago. That's great. We typically would already do that. Like all of our transaction coordinators already sent a critical dates list, but there's a form for it now. Notice to pay rent or vacate. This form is new and has not previously. This is for mainly property management people. But if you have a landlord that's like, hey, these people have not paid rent or whatever, then you can share this form and you can help them with this form, but you're not technically representing them as a property manager. But there's a new form about that. Wire fraud, change the title to consumers beware from buyer and sellers beware. Yeah, that's fun. And that's true. Wire fraud is so scary. Y'all, it's a conversation, it's an email, it's a text message that talks about wire fraud with your people because they just don't have a clue, especially if they're not used to doing a lot with emails and technology and they see all these messages come across. They don't know what's real or what's not real. That is so
And
important.
it looks so real.
It does. Yes.
$1 million. 1.1,
Mhm.
because she was getting the email from the title company and she was getting emails from the fake title company. But because you don't look at the email address, it looks like it's the same. They are so clever. And so then they started talking with her and I was up here busy with something and, she called and I didn't answer immediately. And they had her talked into, after we'd already agreed that she was gonna bring a check, a cashier's check. They had said, you know what? It's really better if you go ahead and just wire us the money. Go ahead and do that. And she went to the bank and she did it. And it was only caught because the bank said, hey, why would you wire this much money to this company? And it said title company on email, but it was to a battery company. And that's how it got caught.
So scary. So scary.
Yeah, good job on the bank.
Okay. There's a property condition statement here. Again, that's a new form. Yeah.
No, there's a disclosure section of the contract. And so what this does is it tells you in advance what the answers are to those questions. So you don't have a blank farm and ranch contract or a blank unapproved contract.
Nice.
I get easily excited.
Yes.
So we used to have an amendment and we were like, just use an amendment. Now there's an amendment for each of the types of contracts. So there's an amendment for farm and ranch, an amendment for the listing, an amendment for commercial. So if you want to do an amendment, then don't just do the blanket one, go and find the one that matches that actual contract. And then commercial lease addendum for expense reimbursement. That's cool, but it's going away. So the other one that's going away is compensation agreement between broker and owner. We already know that. There's no more TX 2401. So we're not doing that form anymore. And 2402 is going away as well. And then if you want to learn more, like I said at the beginning, texasrealestate.com. Well, here we go. TexasRealEstate.com is where I go for a lot of information. They have links to all of the documents. They have an actual form that says proposed changes, accepted changes, and then forms. So you can find all of the details. And in each of those, they have the red lines. So you can see what they've changed or what they've added. So it's really easy for you to kind of get the clip notes about the big ones. The major ones, obviously, today are the no broker to broker things and the way that the buyer gets paid in the contract and changing the paragraph 12 and understanding paragraph 12. That's big thing. And then the groundwater. What questions do y'all have? David? Kelly?
Find everything on that. We're gonna have to do an amendment to listing for any listings that we have out there right now that are broker to broker. And then the broker to broker is going away, so we have to amend the listing. Then they'd be grandfathered in, I would think.
I think the easiest way would be when you get an offer, then you present them with the offer and you amend your listing agreement right then. Say, since they wanted the 3% on the contract, let's amend the listing agreement to make mine 3%. And then that way you don't have to do extra work.
Compliance is our friend.
Yes, we love compliance.
They are. our
They're
friend,
protecting you.
Right? They're out there to look out for you, the brokerage, and most importantly, your client. And so the things they're doing is not to annoy you. So I don't want to see any rolling eyes, eyeballs next month when compliance is asking you to make it or edit a change or make a change, okay? We gotta work together to take care of you, the brokerage, and your client, right?
Yep.
All right.
This is Texas wide, not just our changes. All right, guys, call me or text me if you need anything.